All right, hello, welcome everyone to GovCon Roundup Live. My name is Carroll Bernard. I am the co-founder of Govology.com here, and I'm joined today by Mr. Steven Koprince, my co-host, retired GovCon attorney, and currently he still does some things with us here at Govology, including some webinars and some writing. And so it's really great to still have Steven. We have another guest that I'll be introducing you pretty soon here. First and foremost, I want to put out a legal disclaimer as we do have a couple of attorneys with us today, but the information shared during this GovCon Live show, including the Q&A session, is for general information purposes only and does not constitute legal advice. For specific legal advice to your situation, we strongly recommend consulting a qualified attorney specializing in federal contracting law. And if you're looking for an attorney specializing in contracting law, we like to give a plug to our partners at Koprince, McCall, Potroffs, LLC, who do provide these legal solutions for government contractors. We've got phone numbers and an email address there for them. We'll bring the contact information up back again when we get into the Q&A section here. But before we move any further, I would like to welcome our special guest today, one of the equity partners from Koprince, McCall, Potroff, LLC, Mr. Shane McCall. So Shane, welcome to the show today.
Hello, good to be here.
Yeah. Also, I just want to take a moment to say thank you to Shane and his team, not only for supporting this particular show, but also for showing up and doing many webinars on the Govology platform throughout the year, including the really popular end of the year recap that we typically do. It's always a pleasure to have you guys with us, Shane.
Oh yeah, that's a great one.
Yeah. With that, let's jump into episode number 10. Today, we're going to be talking about expanding VOSB and SDVOSB opportunities and navigating the SBA certification minefield. So, Steven, let's begin with this major legislative update, which is the bipartisan Contract Our Veterans Act of 2026. So this proposed bill would establish a government-wide 5% contracting goal for veteran-owned small businesses and give contracting officers authority to set aside competitions and make sole source awards for VOSBs outside of the VA. So can you give us kind of the cliff notes on this bill, where it stands? What are the chances of it actually becoming law? And maybe before you go into that part, because we may have some new folks to GovCon here that doesn't understand really what the first part is with this environment of SDVOSB and VOSB set-asides and goaling program. Maybe you can give a little background on that and then jump into the bill.
Yeah, no, it's a great place to start when we're talking about expanding veterans' opportunities in federal contracting. And I think just as a refresher for some, or maybe new information for some, just depending on where you're coming from with your background in this topic. So right now, the federal government has a robust preference program for service-disabled veteran-owned small businesses. And those are companies that are owned and controlled by one or more veterans who are service-disabled, who have a service-connected disability, and proof of that status. For veteran-owned small businesses, that is companies that are owned and controlled by folks who are veterans of our armed forces but do not have a service-connected disability, the opportunities are much narrower. And so unlike SDVOSBs, most federal agencies do not have a contracting preference program at the prime contract level for VOSBs. What they have for SDVOSBs, every agency or almost every agency is allowed to do set aside and in some cases sole source contracts for SDVOSBs. And there's a 5% goal. There's a government-wide goal for SDVOSBs of awarding at least 5% of federal prime contracting dollars to those companies. That's a lot. That's billions of dollars every year. The latest stats are out, and the government just met that goal last year just by a hair. It's like 5.01%, but they awarded more than 5% of those federal prime contracting dollars to SDVOSBs. VOSBs are in a different place. If you served honorably, whether it was for just a few years or for 30 years, but you don't have a service-connected disability, then the only agency that currently has a prime contracting preference program for those companies for VOSBs is the VA. The VA does have statutory authority to issue set-aside and sole source contracts to VOSBs. However, at the VA, the VOSBs still are at a disadvantage because there's an order of precedence at the VA where SDVOSBs are prioritized ahead of VOSBs. And so what that means in a lot of cases is that contract opportunities that could have been VOSB set-asides or VOSB sole source end up going out as an SDVOSB set-aside or sole source because of those preferences that VA has. So bottom line is there's a big distinction in the opportunities that are available at the prime contracting level for a company that is veteran-owned and veteran-controlled, depending on whether the veteran or veterans in question have a service-connected disabilities. This new bill is really the third time that Congress has attempted to address that in recent years. And so this bill is called the Contract Our Veterans Act of 2026, and it is a bill that has been introduced in both the House and Senate, and that's common that when there's a piece of significant legislation that House members and Senate members will talk, and they'll introduce a version on each side of the chamber to see if one of them can get some traction. So it's been introduced on both sides. It's a bipartisan bill, has bipartisan support or co-sponsors from both parties. This bill would dramatically change the landscape for veteran-owned small businesses. What it would do, as you said, Carol, is it would create a government-wide preference program for veteran-owned small businesses. It would look a lot like the preference program for SDVOSBs currently. It would give every agency, not just VA, the opportunity to award set-aside or sole source contracts under certain circumstances to VOSBs, and it would create a 5% VOSB contracting goal. So it would essentially put VOSBs in a very similar place to what SDVOSBs currently enjoy in federal contracting. So this bill is currently in the committee level in both the House and Senate, and if it were to move forward as a standalone bill, the next step would be to go through committee, then to the floor of the chamber, and then over to the other chamber. There is an alternate path that it could take to become law, and that's how it got close in the last couple of years. And that is to be wrapped into a bigger package, into an omnibus bill of sorts. And in the last 2 years, the Congress on the House side has actually passed something similar in its version of the annual defense authorization bill called the National Defense Authorization Act. And the House of Representatives, 2 years running, in its version of the NDAA, created a veteran-owned small business preference program. That those last 2 years would have been only for the Department of War, not for government-wide, but it was still an important step. However, the Senate did not agree to it in those 2 years, and so it never became law. So this is the third attempt, and in my article on FedLift Launchpad, I wrote an article on this bill, and because I do this sort of thing, I cited Whitesnake saying, here we go again, because we're trying this for the third time. We'll see where it goes. I know there are a lot of veterans organizations and advocates out there who strongly support this, who say, hey, we got to do more for our veterans who served honorably, who gave so much of their lives to our country, but don't happen to have that service-connected disability. They should have some greater preferences. So we're keeping an eye on that bill right now, but right now in each chamber, it's still at the committee level.
Yeah, and so if we've got any veterans advocates groups out there or people that are really wanting to do something to see this bill go through, right? I know you mentioned it would be probably better if it was wrapped into the National Defense Authorization Act, but right now it's not, correct?
Correct, at least in the versions I've seen. And the latest version of the Senate, as I understand it, is at the phase of the NDAA where there's an initial version that goes through committee, then it goes to the House or to the floor of the chamber, and then individual senators get to propose amendments. And last year, at least on the House side, this is how this got into the bill as an amendment that was proposed. Last I saw, there were like 800 some potential amendments to consider for this bill. So the story is not yet told, and it could go either way. It could get passed as a standalone bill. That sort of thing happens frequently too. It seems to me like a pretty non-controversial bill, but we'll see. So it could go either way as an omnibus bill or standalone. I don't really care how it gets done, but I would love to see Congress move on this, and I know a lot of veterans out there would as well.
How would an advocate or somebody that's lobbying on behalf of veterans reach out to, I guess they would reach out to their congressional representatives to ask that they include it as a provision within the NDAA? Since there's like a higher priority on the NDAA than these separate individual bills, is that what they would do?
Yeah, there are a couple of different things, and I'm no lobbyist. Let's see if Shane has any ideas on this too. So I will say that from that perspective, I can't give you any expert insights from a lobbying side. But yeah, there'd be a couple asks that you could make of your congressional representatives. One would be to simply co-sponsor the bill that's already been introduced that at least shows more support. And the more co-sponsors you can line up, the more the bill appears to have that sort of support. It seems like it should be for a lot of folks a pretty easy one to sign their name to. But if you really want to advance it, and this is the stage, then yeah, see if you can get that. And I don't know where we are in the process of the NDAA, whether new amendments can still be proposed at this point or whether that deadline is passed. But if it's possible to get an amendment into the NDAA, then that would be a great vehicle to do it. So again, I would have to ultimately defer to the professional lobbyists on that topic, though, because that is not my area of expertise.
Yeah. The reason why I was talking about it so much is I know that we had a previous episode where I think, or maybe there was something that you posted on LinkedIn about one of the groups that were working towards some of the women-owned business programs, had some success with getting it into the NDAA, and that kind of now became, although there's some we'll talk about that one next month. But Shane, let's go to you. What are your thoughts on what's happening within this environment right now? And given this news, if you've got veterans that are coming to you in your practice right now saying, hey, what is it that we should be doing right now as a veteran to maybe get ahead or prepare if this does become an actual law? What should we be doing right now to prepare ourselves in advance of this?
Yeah, good question. I did want to make one observation, and I'm happy to get either of your thoughts on this. I did, when I was reviewing this act, it has this restricted competition language. It seems to say, and maybe I'm not reading this right, that the contracting officer has to do a set aside for VOSBs if there's two or more small business concerns. That would create kind of VA Rule of Two, but extend that to all agencies. Am I reading that right? Because that would be a very large change and an increase in VOSB set-asides that's not even currently present, except for the VA having those required set-asides. I wasn't sure if that language was only directed towards VA. It doesn't seem to be in the current version of the bill. So that would be potentially another impact that would be even a greater impact perhaps than the goals if having a required set-aside for VOSBs, if same language similar to small business rule of two. If there's two or more VOSBs that will submit offers and they can do so at a reasonable price, it doesn't seem limited to any certain agencies or anything like that either. That would definitely have a big impact as well. I don't know if Steve or Carol, you read it the same way? Just before I get to your other question.
I'm going to defer to Steven on that one.
Yeah, so my reading of it, and again, I agree that if that was how it's intended, then we've got a different beast, because now you're creating a government-wide preference for VOSBs above everybody else, which I don't think is the intent here. My reading of it was in context, although this is a great question because the language is a little bit interesting on that point, was that the contextual language was the restricted competition versus the sole source, and so that the shall in that case was saying if you've got two or more, you've got to do it as a competition as opposed to doing it as a sole source. At least that's how I read it. It was like if you have two or more VOSBs and you're already decided to use this program, then you must do it as a competition as opposed to doing it as a sole source. That's how I read the shall being in there, but it's a great question.
Yeah. Interesting. Okay, yeah, maybe they will clean that up as it goes through committee. That's the sort of thing they could look at and figure out, is that the intent? Make that a little bit clearer. I would say, though, since it's been introduced multiple times, if it's getting closer to becoming law, companies could certainly think about how they would position themselves for veteran-owned small business certification through the SBA's Vet Cert program. I don't know if when you start that process, but you should start thinking how you could position yourself, looking at the rules for that, looking at the regulations for that, looking at the application process, just as an idea to think, yeah, I could perhaps qualify for this. How would I do that? How early do I need to start that process? Right now, we've had the experience with SBA that their Vet Cert program that's certifying SDVOSB companies and VOSB companies, it works on a pretty efficient basis compared to, it's faster than other types of programs within SBA. But if they're suddenly inundated with a bunch of different companies seeking certification, that definitely could slow things down. Something to think about there. We work with a lot of companies that have more complicated ownership structures, and that's when you might need assistance from a lawyer to explain that to SBA. If you have a simpler structure, sometimes it can be obviously a lot easier to demonstrate ownership and control by a veteran. If there's one owner, there's no minority owners, it's going to be a simpler proposition showing that to SBA than if you've got a company with many minority owners or companies that are minority owners or different classes of ownership and things like that. So that's definitely one idea to think about, how you could get certified or start that process and how that would work.
Yeah, definitely. That's one of the things that I want to talk about next is the certification process. By the way, for those of you guys who are new to government contracting, if you've gone through the SAM.gov registration process or you are about to go through this SAM.gov registration process, there's going to be a little box that you can check off in SAM. It's going to ask you, are you a veteran owned business? Are you service disabled? And you can say yes. This is effectively kind of self-certifying, but you still have to go through the formal SBA certification now. They have done away with self-certifications for VOSB across the federal government for a while now. So you've got to go through this SBA certification process. So next, I'd like to talk about some of the challenges. There's several, but there's some common top ones that kind of hang people up a lot. But before we go to that, I do want to address one thing because inside of the language of this bill, you talk about set-asides, but you also talk about some sole source authority. Can you explain, even as it is today, because right now it's the SDVOSBs have the 5% contracting goal. They have this kind of sole source authority language in there. Can you explain how the sole source authority language works both at the VA as well as outside of the VA? Is it different? For example, like if the DoD wants to do a sole source with a vet versus the VA, and if this bill comes to pass, would that put the veterans' own sole source benefits in a similar framework?
Yeah, it's a great question. And so currently, all the agencies that operate under the FAR, which includes Department of War, VA, state, all those types of agencies, DHS, and so forth, do have authority to make sole source awards to SDVOSBs under certain circumstances, but the authority is different. And unfortunately, off the top of my head, I do not know the dollar limits, but first things first, there are dollar limits for those sole source contracts. And so you have a $1 limit that's a kind of general limit, and a second limit for contracts that are assigned manufacturing NAICS codes. It's a little higher. And again, I just don't know off the top of my head what those dollar limits are under, and I think they may have increased recently, but we can find that out very quickly. So there's a dollar limit for every agency as to how big a contract can be in terms of the dollars if it's awarded on a sole source basis to an SDVOSB. The VA has some special authority for sole sources that other agencies do not. And for most agencies, other than VA, sole source awards are not permitted unless the contracting officer has no reasonable expectation of receiving offers from two or more qualified, capable SDVOSBs were it to be competed. VA, under the certain dollar values, does not have to do that. VA can say, look, we know that if we put this out for competition, we might get 5 SDVOSBs bidding, but you know what? We just like company X, and they're qualified, they're capable, they've got a fair market price. We're just going to do that sole source contract to them. And what that looks a lot more like is the sort of authority that every agency has to do sole sources to 8A companies, because folks will say, why do 8A companies get so many more sole source contracts? And it's coming down now, but why historically have they gotten so many more sole source contracts than women owned, than service disabled, veteran owned, than hub zone? And it's a structural reason. There are 2 reasons for it. One is because certain companies on the 8A side that are owned by Indian tribes, by Alaska Native corporations, by Native Hawaiian organizations don't have to play by the dollar limits. They can get $100 million sole source contracts. So that's one reason. But the second reason is that the agencies don't have to go through the same analysis of, are there 2 or more businesses that might be able to compete this? They can just go ahead and say, yeah, we might, if we competed it, we might get 38 A's that would bid. We're going to award to company X because we love company X. And so that's the second reason why 8A sole sources have been so much more powerful than other SBA program sole sources over the years. And so the VA has authority that looks a lot more 8A, and not coincidentally, if you look at the numbers, a large chunk of the sole source dollars that go to SDVOSBs come from the VA because they have the stronger authority to do those kinds of awards. So that's where it is right now. Previous versions of this bill have said, look, we want to make the sole source authority look for VOSBs look more like the 8A authority. And there's been some, at least, talk about amending SDVOSB authority to do that, to allow that as well. I haven't seen a bill on that. That would take a bill of Congress to do that, but to equalize the sole source authority of the various SBA certification programs. And so as I read it, that's what this bill is hoping to get at least under certain dollar values, because the bill does impose dollar values on dollar caps, essentially, on sole source awards.
All right. Thank you for that explanation because I know that confuses a lot of SDVOSB veterans that I've talked with in the past, and they think that, hey, if there's this SDVOSB like sole source authority, you gotta like contract with me. They don't have to contract with you, and typically they're outside of the VA. There is that process where they still have to seek the set asides first. But that's good to know, and it's really going to be good to see what kind of really becomes of all of this in the future. But given all this news, and given really the only thing right now, I think outside of if you're advocating for this, to maybe reach out to some of your representatives to ask them to push for it, to vote for it, to include it in the NDA if they can. The only thing that really veterans probably can do right now, like Shane mentioned, is to get ahead of it by just going ahead and getting their certifications if don't already have them. And so let's talk about some of the big stumbling blocks. And we can start with you, Shane, because I think you started talking a little bit about this, but the ownership and control. And I also want to specifically talk a little bit too while we're here about why is it so hard for SDVOSB or veteran-owned businesses that own franchises to basically meet this unconditional control requirement, or they get denied because of this control requirement?
Yeah, I can start with the franchise question. And this has been something that's popped up over the years in different published decisions on it. You used to see back when the VA administered, back then they call it verification, pretty much the same thing, but they changed the name for some reason. Back then when they verified companies, VA used to put out some little guidance documents, briefing documents about franchising, and basically saying it's not impossible or it's not strictly forbidden to have franchise company and get SDVOSB certification, but it is very difficult. And we don't have the little guidance documents from SBA, but we have the regulations and we have the case law decisions that have been pretty consistent over the years, basically saying that the veteran owner, the service disabled veteran owner or owners has to manage and control most of the daily actions, most of the actions of that company. There are some exceptions for minority owners for some extraordinary circumstances, such as selling the company. You can have a minority owner in there with some veto powers with a specified list of things related to minority owner investment protection rights. But what we're talking about is a franchise agreement where the agreement says the franchisor, maybe it's a fast food company or something like that, has a lot of very specific rules on how to set up the office and signage and those sorts of daily activities about how to manage your employees, how to run your office. Those are things that have to be held by the control of the veteran. And so if you have your operating agreement will probably stay the same. So the company, maybe it's an LLC, they have their operating agreement that says veteran controls everything, but then you have a separate agreement with your franchise company that says actually you cannot do certain things without the franchise company's approval. That would then violate the control requirements for the veteran. And since a lot of these franchise agreements are covered, all the minutia of running a business tend to cause problems for getting certification for that company, unless you have a big carve out, and I think a lot of these franchise agreements, they're not going to be the type of things where they say, oh yeah, you can edit that, you can change it around however you want. They're going to say, take it or leave it. And if you've already signed it, especially, and then you go in to try and get certified, it could come up and you'd have to produce that document to SBA and they'd look at that and they'd probably say that creates control problems because the veteran cannot control certain daily, ordinary, or policy actions about how running that business. So it's a continuing issue. And I know Steve has talked about this in some of his posts and other people have as well. Could they amend this rule? Could they provide some guidance? But that hasn't happened yet. So it definitely continues to be an issue if you've got that sort of agreement. I will say it's not just franchise agreements. I've occasionally seen other types of agreements that companies have with, maybe it's a consultant or some company they're working with that could have those same kind of restrictions that could cause issues. So you want to be careful when you sign, if you're either a current SDVOSB or you're seeking certification, or like we were talking about, maybe it's a veteran-owned small business that wants to seek certification in the future or already is. What is the impact on these other agreements? And do they have very kind of minute details about operating the company that have to be approved by another business? You wouldn't want to have those sorts of restrictions in another agreement, franchise agreement being the most common. So that's an overview of that situation. What I would say is when you're doing this process, if you're not having a firm like ours do it, you have to look through the regulations and look through your particular operating agreement, look through any other agreements you have, and then you basically cross-reference those against the regulatory requirements. And some of them are specific, but some of them are vague when it comes to control by a veteran. For instance, if the operating agreement specifically gives a veto power to a minority owner that's for something like hired and fired employees, that's almost certainly going to result in a loss of control by the veteran. It's these more ambiguous ones or more nuanced ones where it can be a little bit more confusing. So, for instance, there's a rule about if a non-veteran controls the concern through loan agreements. So you could have a loan agreement that has these various prohibited actions, prohibited things that the veteran-owned company cannot do. But it's okay if it's a commercially reasonable term. So that's something where a typical bank loan is not going to cause that problem. Or the situation where we have economic dependence by the veteran owner on another company. And the regulation calls that business relationships causing dependence so that the veteran cannot exercise independent business judgment without great economic risk, which is a mouthful. The example that VA used to use, and I use this one too because it's hard to wrap your brain around that sentence, is say you have a company, you're seeking SDVOSB status, and you work with some really friendly company and they gave you a lease on your office space and it's so much below market rent. The only way your business could operate is to have that really sweetheart deal on your lease. And arguably, you're so dependent on the other company, basically your company would fail if you didn't have this really below market rent, that SBA could come in there and possibly, I don't want to say it's not guaranteed because this is definitely on a sliding scale, say that landlord, the veteran is so dependent on them, they couldn't profitably operate the business without that sweetheart deal on the lease. So there's economic dependence. So that's one you don't think about, which is why I kind of say all these things should be commercially reasonable. All the things should not be different than what you do with any sort of third party company you're doing business with. And so we kind of got to go through each one. Now, if you're just starting out, you have sort of typical subcontracts, you have a typical commercial lease. Those things, I don't want to get people too scared and say every agreement's going to cause economic dependence. SBA doesn't interpret it that way. It has to be something very egregious. Those are the kind of the steps that we take when we look at these. And of course, people can do that themselves. And a lot of time with our clients, we say, a lot of this stuff will make sense to you. And we typically come in when it gets to the more complicated ones where you're interpreting a more complicated agreement or analyzing it, or, say you have dozens of minority owners, they have all these different classes and shares of ownership. That's an area where you want to be able to explain it to SBA. I sometimes find it with SBA, if they get confused by a presentation of something or how an operating agreement is written, that's when there can be concerns or risks that SBA is not going to approve that certification. So you want to be able to explain it. You want it to be pretty straightforward for them.
Yeah.
Those are some of the issues that come up.
Yeah, and I think as I look at it and talk to a lot of veterans on this topic as well, if you're 100% owner of your company and everything's pretty standardized, you don't have any special agreements with any companies that are just outside of the norm, likely once you go through the certification process and you look at the documents that you need to submit, you'll be pretty much good to go. I do think it's always good to reach out to your Apex accelerator, or if you want to reach out to a GovCon attorney to look at how your operating agreements and bylaws and all that stuff was set up. When you start to basically have partners, it starts to get a little bit more scrutinized. When you have these agreements that come into play, it gets a little bit more scrutinized there. And that's where you want to make sure that whatever, like if you have a partnership agreement, even that basically there's nothing in that basically says that your partners in some kind of scenario would basically be able to own or control your business. And so that's why the more complicated that structure is, the more I would encourage you to reach out to somebody like Shane. And before you go through the certification process and then perhaps get denied, fix all of this stuff so that you go through clean.
I would say one other example that's come up just from different people I've been talking to and different comments we've gotten on our website and things like that is the direct ownership requirement, which seems, you look at that rule, it's pretty straightforward, but I think sometimes people have other goals, obviously, in life. Maybe they're doing some sort of, there's different things, maybe asset protection or something like that, where they have other goals, or maybe there's tax reasons. And so they have a complicated ownership structure. Maybe they've got a trust or
Yeah,
something like
I've heard
that.
that before.
And
Like
then, if you then you want to start your SDVOSB company or you want to get it certified. And the simplest way, what SBA is looking for in the simplest case is directly owned by the actual veteran. So it says their name, John Q. Veteran, as 51% owner of that company. And then, you can't change that. If you change it, you can change it, but you have to notify SBA if you're already certified. If you have a trust or something like that, it might work, but it might not based on how the trust is structured. So again, it definitely goes back to your point, Carol. If you've got a trust, you got to think about it more. If you've got you have a company, you own a holding company and it's got multiple levels of ownership, then you got to think, wait, do I start another company and get that certified as a SDVOSB? Do I merge the companies? Do I transfer ownership? And then maybe all those things are fine, but then you definitely want to document that process because SBA may then ask, we want to see how the fall of the bouncing ball, how did this ownership change? When did it happen? So all those things can be done, but you don't want to go into the process and then learn, oh, SBA didn't like how I set up my ownership structure and then have to change it. It's better to kind of figure that all out ahead of time, like you're saying, on the ownership side and then on the control side. Another one that's sort of come up over the years is certain rights that a minority owner might have with respect to control over the sale, right of first refusal. And SBA did actually make things a little bit easier. And they basically said you can have a commercially reasonable right of first refusal for the minority owner. Before that had been, you couldn't do that. So that means if the veteran owner wants to sell, the minority owners have the right to buy it first. That's the right of first refusal. That used to be not allowed under these regulations, but SBA so they have made things more flexible over the years, and we've definitely read about that on our blog. They used to have a rule that said you had to be within a certain reasonable distance from your office, or you could lose veteran control. That has been gotten rid of. So if you still see that somewhere out there, don't worry about that one anymore. Kind of kudos to SBA for making some of those things less restrictive and more flexible over the years.
They still have the highest officer position requirement. How about the highest paid position? Does the veteran still have to hold the highest paid, or is there some waivers they can say, we have this person at this level? Because how does that work now?
Yeah, the highest compensation rule is still in effect. The highest officer has to have the highest compensation, but like you're saying, it does have an exception. You have to show that if another person in the business is getting higher compensation, you have to show that's commercially reasonable or that the veteran has done that and it's going to benefit the concern. So again, it's one of those where I don't want to get ahead of myself, but there's also full-time devotion. It kind of has that same feature. There's a rule, but then there's an exception. But if you want to prove to SBA that it works, you have to provide a letter of explanation. In the case of highest compensation, you'd want to have some actual facts to show why it's necessary that the veteran would not have the highest compensation. And maybe that's based on your industry. Maybe that's based on the unique nature of that employee that is so crucial to your business that they are really needed to be in there to help the business expand. They have some sort of specialized skill. It's only for a limited amount of time. You could say different things, but it has to be something that's based on your unique circumstances in your industry. So that rule is still in effect, but it needs to be demonstrated to SBA. And in fact, we're talking about that snapshot in time when you get certified, but these rules do continue for however long you want to maintain SDVOSB status. So when you get certified, the CEO is a veteran, they're highest compensated, and that's fine. And SBA approves that. If you then fall below and there's another employee that's getting a higher compensation, you have to notify SBA within 30 days. Similar to if you change ownership, the veteran ownership, you have to notify SBA within 30 days. So these things are ongoing kind of notification requirements, even after that initial time.
This is a great question and we're going to shift now to talking about keeping certification for those who've gotten certified, because there's going to be a point where you have to recertify. It's 3 years, correct?
Yes.
Yeah. So
3
you
years
kind of
unless
go
asked
through the
earlier,
process
standard.
again. Yeah. But if you have changes, like you just mentioned, like let's just say if a veteran sells a part of their company, they have to let the SBA know that, correct?
Correct.
And then they basically get another look. How do they let the SBA know this? Is there a special email address? Do they go back into some kind of certification portal?
Yeah, you have to go through the certification portal. And so, you got to, of course, maintain those logins and things like that, or figure out how to get back in. And then there's a little process where you kind of notify the SBA of that change and then provide the documentation that you upload through through that certification portal. And then it is a 30-day window. And people sometimes say, what if I miss that? I would say, first, try to hit that 30-day window. If not, do it as soon as possible. Explain to SBA why. Give them an honest reason why you may have missed that and give them as much information as possible. We've had that happen with some different companies we worked with, and SBA was, again, somewhat flexible with them. It's not like you're going to be automatically kicked out, but you would want to do that as soon as possible. And by that same token, sometimes people say, I'm proposing this sort of complicated sales structure, and I'd like SBA to approve that in advance. And unfortunately, with the SDVOSB program, they won't do that. You have to make the change, do the sale, and then seek SBA's approval after that.
But before you do all of that, I would say reach out to your GovCon attorney. And this is with anything. Once you're certified, if you've got a company that's even sending you a big agreement that's got a lot into it, and you may, if you're working with a GovCon attorney, just say, hey, can you check this out to make sure it doesn't flag for any potential issues that are going to cost me my certification.
Exactly. We do that a lot.
Yeah.
When obviously it's a more complicated agreement, but yeah, sometimes it happens. Often with the investor coming in, we've definitely seen companies get more successful. There may be these private equity funds. There may be just someone out there that wants to expand these different businesses, and then they can do that. They can have a minority share in the SDVOSB. That veteran can get some return on all of its work it's done over the years through selling part of the business, but then you have to be careful with how you're structuring that and then how you're revising your entity documents. Just like you're saying, Carol, review all of that. SBA does keep some very strong restrictions on those minority owners, and the minority owner may say, I want to have this right and that veto power and this vote. And some of them may be okay, and some of them get too close to the line that you don't want to test it at SBA. We can definitely review those for people. We've done that for a lot of different clients over the years.
Yeah, awesome, man. Steven, you back with us?
Yeah, I think so. So I apologize for that. We're having some work done around the house, and I'm working in a construction zone. I think they knocked the internet out on me while I was here. So I apologize for that. That's all right, because we got Shane here to answer all the questions, and he was rock and rolling. So you guys didn't miss it at all. It's cool.
I'm glad we had Shane here, man, because I wouldn't have been wanting to
hey, you've been going on by yourself.
Yeah. Hey, Steven, now that you're back, I've got a couple of more things I wanted to cover. One of the things, Steven, is something that's frequently overlooked, and it's something very important for those who are actually got the certification and you're participating in a set aside. And this is the overlooking this requirement around the limitations on subcontracting, which is written into the VA acquisition regulation at 852.219-75. Can you talk about within this, what do veterans need to know? I think a lot of people don't even really understand what limitations on subcontracting mean. And then how do you maintain compliance with this as a veteran-owned small business, especially if you're doing business with the VA? Is there a similar certification or provision outside of the VA with regards to what has to be done?
Yeah, so this is a great question. The limitation on subcontracting, for those who are not familiar with just the concept as a whole, it applies to not just SDVOSBs, but applies to any type of small business set-aside or sole source contract that at least is above the simplified acquisition threshold, and applies to all SDVOSB type set-aside contracts, regardless of whether it's above or below the simplified acquisition threshold. And that's just the concept that the government's trying to balance a couple things policy-wise. One is to recognize that, especially when it comes to contracts that are of a certain complexity, dollar value, et cetera, just telling SDVOSB or any small business that you can't have a subcontractor is not helpful, because it means that there will be a lot of opportunities that a small business or an SDVOSB, VOSB cannot successfully pursue and perform without subs, because it's just what needs to be done. And think about a general construction contractor. They typically sub out the trades. They sub out plumbing. They sub out the HVAC. They sub out the masonry, all that sort of stuff. If you say you can't have subcontractors, then they're not going to be able to bid and win the contract. And so you got to allow subcontractors. On the other hand, we don't want to allow just what's called pass-throughs. So it's situations where a small business or some company that's certified SDVOSB, 8A, whatever, wins a contract contract, takes a cut off the top and just subs all the work out to somebody who doesn't have that status, because that doesn't benefit that company. It doesn't benefit the public policy of growing and developing companies that have those kinds of statuses. It just ends up costing the taxpayers more money to get some large business that could have won the contract if it had been unrestricted. There's no public policy benefit to that. So there's this intermediary kind of place where we try to meet those two policies, and that's called limitation on subcontracting. And that says, look, if you are a small business, you're an SDVOSB, what have you, you can subcontract. In fact, you can subcontract to companies that are not small businesses, that are large, but only up to a certain point, unless they're what's called a similarly situated entity, which we won't get into here. And the amount you're allowed to subcontract is going to vary depending on the nature of the contract. And so if it's a services contract, you can subcontract a certain dollar amount. If it's a construction contract, you may be able to subcontract more, because the nature of those contracts and how realistic it is to expect you to self-perform a certain amount of the work versus subbing it out. And so those limits are generally set forth in two places. They're in the FAR clause, FAR 52219-14, which you're going to find incorporated in any contract in which the limitation on subcontracting would apply. And they are also set forth in the SBA's regulations, 13 CFR 125.6. And so those regulations for many years were actually, they had different formulas and such. They're pretty close now, although the SBA has since adopted some changes to its regulation that have yet to be incorporated in the FAR. And then the Department of War came in and did a deviation to match the SBA rules. So there's still some complexities there. So you got to look at your specific contract. For our purposes, the VA under the VAR has gone a little bit farther when it comes to limitations on subcontracting. And the VA has sort of similar formulas as you would find for other types of contracts. You would find the same construction formulas, services contracts, formulas, etc. However, the VA says essentially up front, you've got to submit a certificate that you're going to comply with the limitation on subcontracting. They want that submitted as part of the offer. And so when you're reading that clause, that VAR clause that you referenced, there's a piece of it that says you must fill out the certificate of compliance with the limitation on subcontracting and submit it with your offer. And if you don't do that, we can kick you out of the competition. So it's something to know with the VA. Often this is going to be highlighted in the solicitation itself. It'll be spelled out in full text. But even if they just incorporate that clause by reference, they list the VAR clause number, limitation on subcontracting, it's just like they had spelled it out in practice. So I have seen cases where folks didn't submit the certificate and the VA said, you haven't abided by the terms of the solicitation, which said to be considered, you had to affirmatively comply, to affirmatively submit the certificate of compliance with the limitation on subcontracting, which is not how it works outside the VA, at least not in a clause. An agency could ask that as part of a proposal, but generally speaking, just by submitting an offer that incorporates FAR 52219-14, that the submission of the offer itself is your certificate that you intend to comply. But the VA goes a step farther when it comes to its SDVOSB and VOSB contracts and wants an affirmative certificate. I don't know, Shane, do you have things to add on that? You may have to have some more stories on those clauses too.
Yeah, it's been kind of up a lot lately because it is different. And like you said, it requires that actual signature. We wrote about this case. You might have wrote about this one from this year where the federal judge very much said, yes, if it says you have to sign it, you have to sign it. But I've also seen where the VA itself forgot to check the box of which percentage applied, 50%, 85%. And then they said, well, you didn't comply because the box wasn't checked, which seems harsh, but you definitely need to check that. Or I shouldn't use the word check there. You definitely need to review that part of the clause. Did the VA do it right? Did they check the right box for 50%, for instance, for services versus construction? And if not, then maybe ask a question to the VA, but it's come up repeatedly. So it's a new requirement for the VA. So they're having to implement into their procedures and systems, and there can be mistakes there or confusion. And then there's published decisions on it. And I'll also say the VA does have a kind of a focus on this, because I've seen it with some clients where the VA, so that we're talking about at the offer stage, you must certify to this and sign it. And then during performance, the VA, I have specifically asked for, or I've seen at time of award, they say, actually really explain how you're going to do this. You certified it, now explain it. And during performance, they say, you said you would certify, you told us how you do it. Now prove that you actually met those limitations on subcontracting. I have not seen that as much with other agencies on a regular basis, but the VA does do that. So the VA has a special focus on this. They have a special place in the country. They have a special programs for veterans, but they also put a little bit more hyper focus on meeting these limitations on subcontracting. Not that you should just not follow it with other agencies as well. But if you're working with the VA in particular, be prepared to document it just like you would with any other agency, but even more so with the VA.
Awesome.
Yeah, and I would say that focus on that compliance, not necessarily the clause itself, but the focus on compliance at VA goes back to when I was practicing now 5-6 years ago, and I was working with clients on that too. And VA, I think, really maybe having seen some of the headlines in past years about pass-throughs and such, said, yeah, we're going to make sure we don't have these sorts of headlines. We're going to make sure that our veteran-owned businesses really get the benefits to which they're entitled, and we're going to audit these contracts and make sure that after performance that the SDVOSB prime or the VOSB prime is getting the benefits of the contracts that they're entitled to. So yeah, it's a long-standing focus for VA and something for folks to know. Obviously, you got to comply with these clauses no matter what agency you're bidding, but if you're bidding VA and it's an SDVOSB or VOSB type contract, you should really expect not only to have that front end certificate, but as Shane said, back end compliance review could well happen as well.
Yeah. In the situation of an IDIQ contract, or if they're on GSA schedules, do they have to do this now for each individual delivery order or task order, or do they have to meet the limitations on subcontracting over the life of the contract vehicle? Let's say if it was a 5-year contract, for example, IDIQ may talk with the VA. Do they have to meet the limitations on subcontracting within the 5 years over time? And how is that monitored? Or is it just the one time or per task order when they submit that? Do you know? I'm just curious.
Are we talking about the VA now, or are we talking about?
Yeah, let's say like a VA IDIQ contract, right? And there's a solicitation for a task order.
Yeah, so there are a couple options for that. Depending on the nature of the set-aside contract, it could be the period of performance of each order, or the contracting officer could, at their discretion, as I understand it, require the period of compliance to be the term of the contract. In other words, base year plus each option year. And so that's an issue where, as I understand it, at least you would need to check your contract and say, hey, how are we determining it for this contract? Is it going to be have an order by order basis, or is it going to be over the period of the contract?
Okay.
But not the entire 5-year period, but like base year plus each option year. Because what you have is that there used to be a formula where it was like the life of the contract, including the option years, but then the agency wouldn't exercise the option. And so you'd have a large business be like, we're doing 99% of the work in the first year, and then we'll see what, but we'll make it up in year 5, and then they never get to year 5. And so I think SBA was a little wary about that structure in the past.
Yeah. All right. One more question for you, Steven. You had mentioned something about how veterans can use the 8A program strategically as a part of a broader government contracting growth plan. Do you want to share some thoughts on that?
Sorry, I didn't hear the question that time.
So I think you had mentioned something about how veterans might be able to use the 8A program or an 8A program strategically as part of the broader government contracting growth plan.
Yeah, and this is an interesting one because 8A program is in such a state of flux, as we're going to talk about more next time around. But as that gets ironed out, I think that for me, there's a kind of a false narrative that's out there floating around right now in government contracting, which is that these programs are silos, that you're either SDVOSB or 8A, and if the 8A program gets $1, then it's taking it away from the SDVOSB program or something like that. That's just not correct when you look at the data. In fact, there are a lot of veteran-owned companies that are 8A certified. They have both the SDVOSB or VOSB certification and the 8A certification. In fact, the government, you go back and look at the numbers, and you can look at this on what's called the SBA Small Business Data Hub, where they publish some of the data, and you can break it down by set-aside stats. It's a pretty easy to use site. And it shows there are billions of dollars being awarded to veteran-owned companies under the 8A program. And so why would a veteran-owned company go and get 8A certified? Because that opens up doors to more opportunities. Contracts are being set aside for 8A, as well as sole source opportunities that take advantage of that special 8A sole source authority that currently, other than the VA, agencies don't have. They have to go that, there are 2 or more SDVOSBs that can bid, we have to compete it. On 8A, they don't have to do that. They can just say, hey, we like this company, they're qualified, they're capable, they're proposing a fair market price, the dollar values line up, we're going to award you on a sole source basis. So I think considering that certification on a strategic level makes sense. I would not necessarily apply right now because the SBA has not admitted any 8A program companies in recent months. It's been almost a year, in fact, to my knowledge, since they last admitted an 8A company to the program. And there have been some proposed eligibility changes regarding social disadvantage. So we're going to talk about all this next month. So I think it's something for companies who are SDVOSB, VOSB to keep in mind as a potential add-on to their government contracting arsenal. But unless there's a real reason to go ahead and proceed with that application now, it may be something like, you know what, let's put a pin in that and come back in 6 months and see where the landscape is on 8A and see if this is the right time to apply. At least that's my 2 cents on it.
No, I 100% agree on that. I think it's really important, though, to pay attention with what's happening right now and join us next month. And again, we're going to be doing that on, I think, the second Wednesday of August. And we'll get out some information for those of you guys who are on our email distribution list and everything like that. But we're going to be talking about a couple of current bills that, if they pass, would significantly change the 8A program, as well as the eligibility criteria to get in, which might open the door for people who maybe previously weren't available to get certified in that. So this is going to be something very interesting to follow. Even if you don't get that certification or qualify for it, there is still a lot of opportunities, and it happens a lot where SDVOSBs will team up with other 8A firms. Each of them have their own unique advantages that can be a win-win as well. So think about that from the teaming perspective as well. So that kind of covers the discussion part of that. Shane or Steven, did you guys have anything else you wanted to mention or say?
I think that's good. I would just add, turning back to our limitation on subcontracting item, joint ventures also have some special rules at VA regarding certificates and that sort of thing that are being enforced, at least at VA, and not necessarily as much at other agencies under the SBA rules. I just published an article on a case involving a VA contract in which they excluded a company because the company it was a joint venture, didn't provide some certificates that were required. What we saw on the limitation on subcontracting side said this time was joint venture related certificates. And those are certificates that are required actually under the SBA rules, but VA adopted those in its solicitation, said you have to submit them. Company didn't do it. They got kicked out. And GAO said, yep, and got kicked out. So just keep that in mind. There's just some extra paperwork requirement when you're dealing with these kinds of SDVOSB contracts sometimes, but it can still be well worth it because there's a lot of dollars. Like I said, 5% of federal prime contracting dollars for these companies last year. It's a very valuable certification.
Absolutely.
Yeah, thank you, everyone. These rules can be pretty complicated, so it's always good to get assistance on the front end rather than getting challenged on the back end. So call someone like Shane if you have questions. But I've worked with a lot of clients who've been very successful winning contracts, subcontracts through this program. So it's absolutely worth pursuing if you qualify.
All righty. Thank you so much, Shane. Thank you, Steven, for being with us today. Great information. But for now, we'll say goodbye to Shane and Steven. And again, thank you guys so much for joining us. Shane, thanks again for supporting the show, and we will see you guys again pretty soon.
Thank you. Thank you both. Appreciate it. Thanks, everyone, for attending.
All right. Take care.